Who is allowed to revoke a will? Have you ever wondered who has the power to change or cancel a will? It's a key question in estate planning and understanding the probate process. The answer is straightforward. Only the testator, the person who created the will, can revoke it. This right is valid as long as the testator is alive and mentally capable of making decisions. Once the testator passes away, the will becomes a binding legal document that cannot be revoked by anyone else. If the testator becomes incapacitated and unable to understand their actions, they generally lose the ability to revoke the will. So, it is essential for the testator to act while they are still able to make clear decisions. Revocation can happen in several ways, and each method requires the testator's clear intent to cancel the existing will. One common way is through physical destruction. The testator can revoke their will by tearing, burning, or otherwise destroying the document. However, this destruction must be intentional. If the will is damaged accidentally, that does not count as revocation. In some states, the testator can ask another person to destroy the will on their behalf, but the testator must witness this act. Another method of revocation is creating a new will or a codicil, which is an amendment to the will. This new document must explicitly state that it revokes any earlier wills. Certain life events can also lead to automatic revocation of a will. For example, marriage, divorce, or the birth of a child after the will is executed may change or revoke parts of the will, depending on the laws of the state. It is important to remember that simply making notes or marks on a will does not invalidate it unless there is a clear intention to revoke. The testator's intent must be evident and deliberate. From the perspective of elder law and estate planning, ensuring that revocation is done correctly is vital. If a will is lost, destroyed, or revoked improperly, it can lead to confusion or disputes during the probate process. This may result in the estate being distributed according to intestacy laws, which are the default rules when no valid will exists. Consulting an experienced estate attorney when revoking a will is highly recommended. This ensures that the process follows state requirements and accurately reflects the testator's wishes. Understanding who can revoke a will and how to do it properly can save families from unnecessary stress and legal challenges later on.